Welcome, everyone. I'm Mika Domingo, CCCBA board member and chair of the Diversity, Equity, and Inclusion Committee. Thank you for joining us for our plenary keynote address. Before we get started, I would like to introduce Joanna Barron, Vice President of ADR Services, Inc., who is sponsoring this program today.
Thank you, Mika, and thank you to the Contra Costa County Bar Association for hosting this highly informative and valuable event, and for inviting our firm to sponsor and support our legal community. ADR Services, Inc. is a leading provider of alternative dispute resolution services in California. We provide mediation, arbitration, judicial, and discovery referees, along with a whole host of alternative dispute resolution services. With 7 offices statewide, we pride ourselves in offering unparalleled resolution services through our exclusive panel, which is comprised of more than 140 of the most distinguished and talented neutrals across the state. ADR Services, Inc. has been recognized as having the best neutrals in the business, and we make a concerted effort to maintain the high caliber quality of our panel through thoughtful and selective recruitment. Diverse backgrounds and experiences on the bench and in the legal field allow us to steer their talents toward the right case, while their varied personalities permit our clients to find a match that will lead to a successful resolution of their matters. I would also like to take this opportunity to announce our new state-of-the-art bespoke case management system called AMS Case Management System, which will benefit our neutrals, clients, and staff. With access to this cloud-based software program, clients are able to track upcoming cases, maintain document storage, and pay invoices all online at the touch of their fingertips. We are constantly striving to redefine and improve our operational process to better support our clients and have designed the system with exactly that in mind. Thank you again for your time and support. And without further ado, I'll turn this back to Mika.
Thank you, Joanna, and thank you, ADR Services, Inc., for your sponsorship of this program and continuing support of CCCBA and the MCLE Spectacular. Our sponsors are a very important part of our CCCBA community. They make it possible for us to provide programs like this. Please support us by supporting them. On behalf of the Contra Costa County Bar Association, I would like to welcome you to the 26th annual MCLE Spectacular and our plenary keynote, Examining Racial Bias at the Intersection of Housing and Policing, presented by Novella Coleman, Director of Litigation at Bay Area Legal Aid. I hope you enjoyed this morning's programs. Things are off to a spectacular start. This afternoon, I invite you to join me and visit the section networking rooms and our sponsors' meeting rooms, which will be open from 1:30 to 3:30 p.m. At 2:30, we have our law firm marketing forum. I know the presenters, so you won't want to miss what they have to say. Then at 4 p.m., there will be 2 more MCLE sessions. And finally, at 6 p.m. on our main stage, some entertainment will make you smile. I would now like to introduce our speaker, Novella Coleman. Novella Coleman is a Director of Litigation at Bay Area Legal Aid. She leads, supervises, and trains staff attorneys in developing and litigating impact cases arising out of Bay Area Legal Aid's direct services work on behalf of low-income persons in the 7 Bay Area counties. Bay Area Legal Aid's docket covers a broad range of substantive areas, including housing law and homelessness prevention, economic justice, consumer law, family law, healthcare access, immigration, civil rights, and legal issues affecting the re-entry population, youth, and veterans. Novella was previously a staff attorney at Policy Link, where she litigated in the criminal justice space. Before that, Novella was a staff attorney at the ACLU Foundation of Northern California for 7 years, where she engaged in legal and policy advocacy, advancing civil rights and civil liberties. Novella is a graduate of Harvard Law School and Stanford University. At this time, I would like to pass the program over to Novella Coleman.
Thank you so much for that introduction, Mika. So today we'll be examining the intersection of housing and policing and how racial bias operates in that area. Given the economic downturn we're experiencing as a result of the COVID-19 pandemic, housing security is of critical importance. The local, statewide, and national responses of government actors have already widened housing security disparities. For example, renters are experiencing housing insecurity at a rate nearly twice that of homeowners. 32.6% of renters report being housing insecure since the start of the pandemic, compared to 16.6% of homeowners. In 2017, 19% of white renters reported housing insecurity, growing modestly to 22.4% amid the COVID-19 pandemic in 2020. By contrast, housing insecurity among Black renters increased from 33.5% to 44.8%. We are also in the midst of a grassroots field effort that is shifting the public discourse about policing and law enforcement. The experiences of people of color who live in heavily policed neighborhoods and individuals who are policed no matter where they reside has broken new ground in social media, in the news, sports and entertainment, and even among private corporations. So now, more than ever, it is important to be aware of how the legal prohibitions on racial residential segregation and racially motivated policing impact communities of color. We know that racial inequity in housing persists, and social science gives us a lens to examine the limitations of anti-discrimination law at the intersection of housing and policing. So for the agenda, I'll begin with an overview of racial bias in housing, identifying the associated harm and the laws adopted in response. I'd like to then focus on the way the legal landscape changed during the civil rights movement of the 60s and offer a critique of the traditional framing of that time period. I'll then use that critical lens to identify police practices that contribute to the subordination and domination of people and communities of color in residential neighborhoods. Those police practices include the drawing of police district lines, the creation and operation of special police units, how neighborhood boundaries are policed, tenant criminal record screening, and the enforcement of crime-free ordinances and policies and related practices. After my presentation, we'll have a Q&A. So I will briefly go over the history of racial segregation in housing. I'm sure many of you are familiar with the highlights of that era. It was marked by racial violence, racially restrictive covenants, residential steering, and a practice called blockbusting. The bottom picture here is from 1979. It shows a Black man in the city of New York who discovered racist slurs on the front of his house. Harassment like this and other acts of racial violence continue to this day. Some of you may have heard about the incident in 2017 where LeBron James's home in Los Angeles was vandalized when someone spray painted the N-word on the front of his gate. Another marker of this era was racially restrictive covenants. The top picture is a property title document in Contra Costa County. A woman bought this house in 2010 and discovered the property documents said the home could not be owned or occupied by anyone who was not of the Caucasian race. Also, Richard Rothstein's book, The Color of Law, tells the story of a Black physician named DeWitt Buckingham who bought a house in Berkeley's Claremont neighborhood from a white friend in 1945. A local neighborhood association sued, citing the restrictive covenant in the property documents, which said that only those of pure Caucasian blood could live there. A state court actually ordered Buckingham to move out, but fortunately 3 years later, the Supreme Court forbid enhanced enforcement of racially restrictive covenants and Buckingham was allowed to stay. Now such rules are prohibited by federal and state fair housing law. And another example of this in the Bay Area, there was a Hillsdale neighborhood reported in the New York Times just this summer that described a racially restrictive covenant that read, "No persons other than members of the Caucasian or white race shall be permitted to occupy any portion of said property other than domestics in the employ of the occupants of the premise." Today, most racially restrictive covenants come with a disclaimer saying that they're void, which is a requirement of state law. And in 2000, the California legislators set up a process for homeowners who want to go a step further, allowing them to add a document to their file with the racial language stricken out. So for those of you that are homeowners, you may want to look at your property documents and pursue that remedy in the name of racial justice. Other markers of our history of racial segregation in housing include exclusionary zoning. The city of Berkeley was actually the first US city to implement single-family zoning. That was in the Elmwood neighborhood in 1916. We also know, and this top picture is an old picture of Elmwood during that time. The bottom picture shows a racially redlined map in the city of San Jose. Redlining was a process where the Homeowners Loan Corporation, a federal agency, would give neighborhoods ratings to guide investment. Neighborhoods that were predominantly home to communities of color were marked hazardous by red, hence redlining on the maps. And this made it hard for Black people who were residing there to get loans for home ownership or maintenance. And this led to cycles of disinvestment in Black communities. So we know that we've been plagued by a history of racial segregation. And then between the 1940s and 1970s, fair housing advocates worked to dismantle de jure segregation, meaning segregation mandated by the law. So here's just a broad overview of changes in the federal law. So the first case, 1948, was outlawing racially restrictive covenants. We saw the passage of Title VI of the Civil Rights Act of 1964, prohibiting racial discrimination in federal programs. Title VIII of the Civil Rights Act of 1968, specifically prohibited discrimination in the sale, rental, and financing of dwellings and in other housing-related transactions based on race and other protected categories. And so those are just examples of the changes in federal law that we really can celebrate that is moving us toward overcoming our history of racial segregation in housing. We can also look to parallel provisions in California law. I won't go through each of those in detail, but you should know that the California Department of Fair Employment and Housing has an excellent overview of California law, and that will also be provided in the MCLE materials for this session. So when you take a step back and think about the traditional framing of the civil rights movement, there's an inclination to view the history of race in America as a consistent movement toward progress. And an interesting quote that I heard from Brian Stevenson, who's a human rights lawyer in Alabama, he says, "I hear people talking about the civil rights movement and it sounds like a 3-day carnival. On day 1, Rosa Parks did not give up her seat on the bus. On day 2, Martin Luther King led a march on Washington. And on day 3, we just changed all the laws." But the reality is that for decades, we, American society, humiliated people regularly. And social scientists have found that this inclination, this framing of the traditional civil rights movement has actually been documented. So a 2020 study found that reminding white Americans about the persistence of racial disparities actually caused them or resulted in them overestimating how much progress has been made and toward racial equality between 1963 and 2016. Another study in 2017 found that both white and Black Americans show a tendency to overestimate current racial economic inequality. A significant status divide exists in the size of these misperceptions. So high income white Americans in the study overestimated current racial economic equality much larger than those generated by low income white Americans and Black Americans across any income distribution. In that study, inducing participants, mostly white, to think about Black individuals and families that are similar to themselves and to their own families increases the tendency to overestimate racial equality, whereas increasing the salience of societal racial discrimination reduces it. So you can think about it, if white people of a higher economic class are thinking of their experience and they think directly about those of their colleagues, so maybe white attorneys thinking about the experience of a Black attorney that they work with, that thought results in them overestimating how equal society is. But when they take a step back and think about societal racial discrimination overall, there's a reduction in how much they overestimate equality, although that overestimation is still there. So this is just something to really be aware about, because especially as folks in the legal profession, it's easy to assume that we know that our country has a history of racial inequality, and to assume that we're accurately thinking about that in the past and in the future. But the social science tells us that we more often than not are actually overestimating how much progress society has made in this area. And just a statistic to bring that home is the average Black family earns just 60% of what the average white family earns, and has 1/10 of the net worth. And that gap has scarcely budged since the 1960s. So even though all of those laws changed in the 1960s and we made some really great progress on the legal books, the reality is that racial economic inequality persists to this day. And also de facto racial residential segregation continues to exist. So 2000 census data showed that the average white resident lives in a census tract that is 79% white, although whites represent only 64% of the general population. And the average Black person resides in a tract that is 46% Black, so closely concentrated, compared to their 13% share of the general population. And then that census data also looked at the Hispanic category and found that the average Hispanic person lives in a tract that is 45% Hispanic, which is also heavily racially concentrated, compared to Hispanics' 16% share of the general population. So we know even after all of these amazing changes in the books and in the law and on paper, that in practice, racial economic inequality persists today, and racial residential segregation persists as well. So legal scholars have looked at that phenomenon and looked at the way the Constitution frames equality as a way to better understand why we have this gap. So when you look at the Supreme Court's jurisprudence under the Equal Protection Clause, We have the key case of Washington v. Davis, which in 1976 held that a racially disproportionate outcome is not the sole touchstone of invidious racial discrimination forbidden by the Constitution. So racially disproportionate outcome under the Constitution does not alone trigger strict scrutiny. And then the court clarified even more in 1979, and this was a case about sex-based discrimination, but it applies equally to race-based discrimination. So under the Equal Protection Clause, discriminatory purpose moves more than intent as volition or intent as awareness of consequences. It means the decision maker has to have selected or reaffirmed a particular course of action, at least in part because of, and not in spite of, its adverse effects upon an identifiable group, whether that's race or gender. So looking at this framework, legal scholar Charles Lawrence offered a critique. He noted that the traditional notions of intent do not reflect the fact that decisions about racial matters are influenced in large part by factors that can be characterized as neither intentional in the sense that certain outcomes are self-consciously sought, nor unintentional in the sense that the outcomes are random, fortuitous, and influenced by the decision maker's beliefs, desires, and wishes. So I think just thinking about it in an everyday context, people make decisions all the time and don't necessarily understand in the moment what all of their true motivations are. So of course, that same phenomenon of how people operate and function and make decisions applies in the area of decisions that affect race. So as a result of that and the research of a number of social scientists, there's a growing body of research that recognizes the pervasiveness of unconscious racial and ethnic stereotyping and group bias. So there's been an increasing recognition of the natural human tendency to categorize information and engage in generalizations. And that's should be a little bit common sense or intuitive. So every time you take in information, you don't always pick up on all the details. Generalizing helps us process our sensory inputs. And so in this case, the Northern District of California recognized that these unconscious processes can lead to biased perceptions and decision-making, even in the absence of conscious animus or prejudice against any particular group. So in Chen v. Reynolds, in that particular case, the court was examining the disproportionate number of Asian persons who were in a jury in a criminal case and found that there may be biases pertaining to the leadership qualities of Asian people that are influencing whether or not Asian persons are selected for the jury or selected as the head of the jury deliberations. I think Jennifer Eberhardt, who's a researcher at Stanford University, puts this well, because I think a lot of times we say like, oh, everybody has bias, and that can sort of undermine the weight of how consequential it can be when individuals operate on that bias. And then at the other extreme, I think sometimes people think that implicit bias is just like some word that we landed on so that we could secretly call other people racist without offending them. And so that's really not how I'm using this term here, and how people who have researched this use the term implicit bias. So Professor Eberhardt says implicit bias is not a new way of calling someone a racist. In fact, you don't have to be racist at all to be influenced by it. Implicit bias is a kind of distorting lens that's a product of both the architecture of our brain and the disparities in our society. And so all of the disparities that I talked about before when it comes to segregation and what populations people are exposed to in their home life, in their neighborhoods, as well as the disparities in income, those things, that part of the structure of our society is going to influence how our brain processes information. And just to put a point on it, Professor Eberhardt tells the story of when she and her son, Everett, were on a plane. This is in her book, Bias. Her son was 5 years old, and he was new to being on planes and just looking around, and he saw a Black passenger. And he said to his mom, "Hey, that guy looks like Daddy." So Professor Eberhardt describes how she looked at the man, and she really didn't see a resemblance between him and her husband, and that's a picture of him there, of her husband, also a professor at Stanford Law School. And she says she looked at them. Her husband's bald, and the guy her son was pointing to had long locks. The guy that her son was pointing to was shorter than her husband. The skin tones were different. She didn't really see any similar facial features. And so Professor Eberhardt was prepared to lecture her son, all Black people don't look alike. But before she could begin, her son looked up and said, "I hope that man doesn't rob the plane." And she was a bit taken aback, and she asked her son, "What did you say?" And he repeated, "I hope that man doesn't rob the plane." And she asked her son, why would you say that? And he said, "I don't know why I said it. I don't know what I was thinking." So clearly, even at the age of 5 years old, her Black son, as a result of the racial disparities that exist in society, the neighborhood structures, how people are portrayed in the news, on TV shows, how other people around him maybe talk about Black people, was able to gather that when you see a Black man, there may be a reason to be afraid that that person is going to commit a crime. So I think that just illustrates it's really not about, she's not calling her son racist. She's saying her son, even at the age of 5, has been influenced by racial bias that exists in society, and that racial bias can be primed within him when he sees a stranger on the plane. And we know also just from the research that was cited by the Supreme Court and Brown v. Board of Education, that there's a lengthy discussion about how kids would prefer white dolls over Black dolls. So we know that this stigma that is perpetuated by the inequalities in society when it comes to material things, and this narrative of racial difference actually influences how people of all races and ethnicities respond to Black people and to people of color. So the particular implicit stereotype or unconscious stereotype, sometimes it's an express stereotype depending on who you're interacting with, that I want to talk about, is the Black Crime Association. So there is a documented stereotype for almost 60 years of depicting Black Americans as violent and as criminal. And this has been, This has been demonstrated in a number of studies. So when police officers were exposed to crime-related words, they paid more attention to Black male faces, meaning they were more likely to initially look at a Black male's face and continue to look at it. They were also more likely to falsely identify a face that was more stereotypically Black. So often in the studies, stereotypically Black will correlate with darker skin, broader noses, wider lips, some of the characteristics that society has stereotypically depicted Black people as. When police officers were asked who looks criminal in these studies, they chose more Black faces than white faces. Another study found that when people were asked to envision a drug user, 95% of the respondents pictured a Black drug user, while only 5% imagined a drug user of other racial groups. And there's plenty of research showing that drug usage rates are quite comparable across different races. When participants only had a half second to respond, they more readily made a false claim of seeing a weapon if they were primed with a Black face. So if they were shown a Black face rather than primed with white faces. So when you think about all of the recent stories we've been hearing in the news about police shootings of unarmed Black people, we need to view that in the light that their implicit racial bias can actually cause this misperception where police officers might falsely think that someone has a weapon if that person is Black, but in a comparable situation with a white person, they wouldn't make that false perception. And there have also been a number of shooter studies where participants are made to decide in like a video games type of stimulation whether to shoot an armed target. And in those studies, they would shoot more quickly if the armed target was Black, and they also would not shoot an unarmed target more quickly if he was white. So there was a lower frequency of unarmed white people being shot in the study because the shooter falsely thought that that person might be armed. So all of this research really does point to a troubling phenomenon where we know that there are situations that can trigger implicit racial bias, and we also know that explicit racial bias still exists today. However, the ways that our equal protection law is written, especially the constitutional law, as Charles Lawrence points out, doesn't acknowledge that someone might be acting because of race, but not even be aware of it. So it'll be harder for actors themselves and also for courts to detect that invidious discrimination is occurring. So what this means for housing is that we know racial segregation has been framed as the product of intentional individual choices of quote unquote racist bad actors. But a legal scholar named Monica Bell has suggested this reframing of how we should think about racial segregation. So she says, segregation entails uneven geographic distribution of ethnic groups across a coherent geographic area. So the regular aspect of segregation is that we think about when we hear the word is physical separation. One group geographically is condensed in one area, another racial group is geographically condensed in a different area. They're physically separated. But another aspect of segregation, as she's reframing it, is the movement of marginalized ethnic groups into identifiable and stigmatized enclaves. So when the way we think about this is all of the racial steering that I pointed to from the past, that can have the effect of pushing white residents to one neighborhood and Black residents to another. Also the block busting practice where realtors would, when Black families moved in, tell the white homeowners that's going to decrease the property value, and that was then a trigger for white flight out of those neighborhoods, and then the realtors would turn around and sell those homes at a marked up price to Black families. So those type of practices that steer people into different geographic areas based on their race, that's another aspect, concentration, that fuels segregation. Another is what she calls subordination, and this is where police practices come into mind, is that in order to establish and reproduce segregation, there's also a racial hierarchy in which individuals are ranked in society based on their race. And receive different treatment. So once you've been steered into a Black neighborhood or a white neighborhood, you then might experience different interactions with the police. They might use more heavy-handed and sometimes illegal law enforcement practices in a Black neighborhood that they wouldn't use in a white neighborhood. And then the final aspect that she identifies is domination, which she describes as the control and economically exploit the disadvantaged group. So blockbusting is like another example of that. So in all of those ways, Monica Bell says her theory is that policing contributes to the reproduction of racial segregation. And so when we take a look and see that segregation is more multifaceted, then we realize that framing our goal as equality, which under our law in the United States is typically you treat like groups alike, that doesn't quite get to every aspect of the problem because we still have these disparities persisting. So a number of folks in the civil rights and human rights movement have adopted what they call the equity framework. And so that's something I was introduced in my time at Policy Link. And that's defined, equity is defined as just and fair inclusion into a society in which all can participate, prosper, and reach their full potential. So it's more than just treating people the same. Equity is about unlocking the promise of the nation by unleashing the promise in all of us. And a great example of that is the disability rights movement in the United States. So when you look at a lot of anti-discrimination laws that affect people on the basis of race or sex, they tend to be framed as don't treat people who are the same differently. But when you look at equal protection or anti-discrimination laws in the disability context, the framework is to actually consider the differently abled aspects of an individual and then provide a reasonable accommodation so that that person can have meaningful access in the same way as people who aren't disabled. So I think the reasonable accommodations approach, as opposed to, let's not treat people differently who are the same, really does a better job of embracing where we want to move into as a society. And just by way of reference, if you want to take a look, there is international law can sometimes be a useful comparator. And so RV Cap is a recent-ish case in Canada that describes how in Canada, their equality law actually does more resemble the equity framework than it does the formalistic approach to equality that most of us are familiar with. So reframing how we think about racial inequity in housing, one pit stop is also, in addition to considering implicit racial bias, is to consider race and space. So it's not the case that people are just discriminated against based upon their race. It's also the case that actual spaces or neighborhoods are perceived differently based on perceptions about the racial composition of that neighborhood. So there's a 1992 through 94 study that surveyed respondents in 4 cities and 4 racial groups to see how comfortable people felt with living in racially integrated neighborhoods. The white respondents indicated that they felt comfortable with some level of integration, up to 1/3 non-white. So, but once the population, the neighborhood population, went above 1/3 non-white, there was a sharp fall in how much the white respondents would then feel comfortable living in that neighborhood. The lowest levels of comfort emerged for integration with Blacks. So that was the racial group that made the white respondents feel even less comfortable living in an integrated neighborhood. Less than 40% of white respondents reported feeling comfortable if 8 out of 15 of the homes were Black, and less than 30% of white respondents expressed a willingness to move into such a neighborhood. So the perceptions about the neighborhood is definitely part of the calculus when you look at why racial segregation in neighborhoods persists to this day. A study that was published based on data from Chicago also found a positive relationship between race and how people felt about neighborhoods. Here, they found a positive relationship between the percentage of young Black men in the neighborhood and the perception of crime. And the telling part is that positive correlation existed even when you accounted for the actual crime rates. So more than the reality of what the crime data is, and is informing how people feel about neighborhoods where there is a higher makeup of young Black men who reside there. And then finally, there's this study about the Bay Area where adult residents, mostly white and Asian, were asked to evaluate a house for sale. And the participants evaluated the house for sale by a Black family. So when they were told similar properties, but one group was told this is being sold by a Black family, the other one was showed this is being sold by a white family. Those who were told it was being sold by a Black family rated the same property and neighborhood more negatively when they thought it was a Black person's home. So given these biases, these explicit racial bias, implicit racial bias, the way space is racialized, we see a number of current police practices that are contributing to racial inequity in housing. And now I'll go through examples of those. So the first one is the drawing of police district lines. One way that policing constructs urban space, and this also would apply to rural space or suburban space as well, is that police departments segment their neighborhoods into districts or precincts and other service areas. So Professor Gordon studied a Midwestern police department and its redistricting process. And she found that the process functioned more like an enforcement mechanism for harsh policing in the predominantly Black district, whereas in the predominantly white district, policing was approached with a client service model. So another way to think about that is in the Black neighborhood, policing was there with sort of like an enforcement mentality, like they were moving into hostile ground, whereas the policing in predominantly white districts were more inclined to see the residents as like their clients and they're trying to provide a service to them. The residents of the predominantly Black district in this study also wanted police to help them, just like everyone else, but the law enforcement agency just took a different approach to policing And that is no doubt informed by these biases that we've identified. So in that district, the department dedicated more than 10% of the officers to the predominantly Black precinct, and also to special units, so that it could be more proactive about focusing on things like violence, gang activity, and drug crimes. And these officers spent most of their time conducting stops through the precinct. So the activity was different, the approaches were different. And unsurprisingly, there are racial disparities that exist in police stops, pedestrian stops by the police, car stops by the police, and arrests by the police. In fact, the San Francisco Lawyers Committee of the Bay Area just issued a report showing that for low-level offenses, so what we think of quality of life offenses like jaywalking, where you wouldn't expect an actual difference in how much people of different racial groups jaywalk, there is in fact racial disparities in how law enforcement enforces things like jaywalking. And all of that is tied to the different approaches that are taken in these racially segregated neighborhoods and districts that the police are creating. And them creating those district lines allows them to very clearly take different approaches in different neighborhoods, provide different training to officers based on where they're being placed. Another practice that leads to racial disparity in housing, which I just alluded to, is the creation of these special police units. So these types of police units include gang units, narcotics units, homelessness task force, and then also things that are more like neighborhood watch. So in Dallas, Texas, there is a neighborhood watch program that's called Expanded Neighborhood Patrol. But in fact, what it is that the law enforcement there is working regular like it does in both districts. So when whether it's a white district, white neighborhood, or a Black neighborhood, they have regular hours for law enforcement. But then homeowners associations are able to assemble and actually pay the police department for additional access and services. So taking on this client model where they can pay police officers overtime, who then provide an extra layer of security or maybe even just comfort to white residents in those neighborhoods, knowing that the police are there to respond to their calls. Another example of this just different approach to policing. So in a lot of neighborhoods, public housing units are policed differently than private housing units, and then especially different compared to residential private housing in white neighborhoods, like the Expanded Neighborhood Patrol in Dallas, Texas. So one individualized example of this is in 2014, a 28-year-old Black man named Akai Gurley was fatally shot by a rookie NYPD officer named Peter Lang. The officer was patrolling a Brooklyn housing project, and he said he accidentally fired his weapon when he heard a noise in a darkened stairwell, and the bullet ended up ricocheting off the wall and hit Gurley and killed him. So when you think about all of these studies showing that the perception of dangerousness and whether or not somebody is armed with some kind of weapon or a gun, that is influenced by whether they're primed with Black identity. So this officer being in a Brooklyn housing project may have been primed to think like, I'm in a dangerous place because this is where Black people are concentrated, and it results in the death of an innocent 28-year-old Black man. A more large-scale example of these different approaches to policing and special police units is the Williams v. City of Antioch case that was litigated in the Northern District of California. This case is really significant now because a lot of the things that went into these gross manifestations of racial segregation in housing were actually fueled by the economic downturn in 2008 and 2009. So as people were losing their jobs and losing their homes during that time, just like now, although now is probably going to be much worse, there was a lot of mortgages that were getting foreclosed, particularly in neighborhoods like Antioch, where prices had been inflated. So a huge number of people, mostly white residents, were being kicked out of their homes, and landlords were left with these empty homes to rent. And so one way of securing a stable rental income is actually through Section 8 or housing choice vouchers, because the federal government is guaranteeing that they're going to pay a large proportion of the income. So a lot of houses in Richmond were turned into houses that would accept Section 8 housing choice or Section 8 or housing choice vouchers. So there was an increase in the program. And that caused a huge demographic shift in Antioch. People were moving, Black people were moving from Oakland to live in Antioch. And there was a racist backlash to the increased presence of Black people there. The police actually responded with creating a special unit to police neighborhoods to respond to things like people playing basketball at night and there were complaints that they were too loud, or people would be outraged that someone on a public housing voucher could live in a home with a swimming pool. There was a sense that the stereotypical Black welfare queen shouldn't have access to a swimming pool. There was a lot of resentment there. And then there were also people complaining that possibly unauthorized residents were living in the house. And so to address these complaints that were actually, in many instances, fueled by racial bias of white residents, the police created a community action team to target public housing voucher holders in investigation and enforcement of complaints and complaints about nuisance. And the plaintiffs in that case alleged that the brunt of these investigations were actually falling on Black people. So 14% of Antioch households were Black, but they were 2/3 of all of the community action team investigation. So there was a racial disparity there in who was targeted. And there was also a racial disparity in targeting public housing voucher holders for investigating these complaints. The complaints and the documents in that litigation tell many examples of Black residents and Black women in particular who were subject to heavy-handed law enforcement activity, unlawful entries and searches into their home, false allegations about their families. Even in some instances, folks were alleging that the children of these Black homeowners were being truant in school, and there were attempts to use the alleged truancy of the children as a criminal activity that could then be used as a basis for kicking these Black residents out of their homes. The case was settled in 2011 with changes in written policies and practices to shift away from focusing police enforcement on voucher holder status and on race as well. Another example is from Antelope Valley in Los Angeles. In this case, it was actually the federal government, the Department of Justice did an investigation into the LA Sheriff's policing in Antelope Valley and found that the sheriff was devoting excessive resources to policing Antelope Valley participants of the Housing Choice Voucher Program between 2004 and 2011. This was in large part because of whites' sense that their racial dominance in the region was threatened because of the increasing racial diversity in the area. Much of the change here was from a growing Latinx population, and then the Black population had increased somewhat. That voucher holding status was being used as a proxy for Blackness, and white Antelope Valley residents deployed the county sheriff's department to expel and repel voucher holders, hoping to stave them off. And the DOJ found 2 Antelope Valley municipalities were in violation of federal law. And one of the things that was in violation was that they entered into, the sheriff in the city entered into a memorandum of understanding with the local housing authority that included a provision for voucher fraud investigations. So essentially, former sheriff deputies were being fueled to investigate alleged voucher fraud, which is correlated to a lot of the stereotypes about cheating the system, the whole Black welfare queen trope and stereotype, which has fueled our housing policy. And now this was also fueling criminal law enforcement activity. So the DOJ ended up entering into a consent decree in that jurisdiction to stop some of the bad practices there that included targeting people based on their voucher holding status and their race as well. Another police practice that contributes to racial inequity in housing is the policing of boundaries. So I already spoke some about the expanded neighborhood patrol in Dallas, but there are also plenty of individual examples. So many of you probably heard about in 2009 when Harvard professor Henry Louis Skip Gates was actually arrested because a white neighbor called to say that he was breaking into what was actually his own home. There was also an even more recent incident in just this summer. A Santa Clara University professor named Danielle Morgan and her brother were on the campus where she had a house, and her brother was walking around the neighborhood, just taking a walk, looking around, and a police officer saw him, deemed him suspicious, and followed him back to her house. And then when the police got to her house, they questioned her extensively about why she was there. She said she lived there. They asked for her ID. And there was an extensive back and forth where basically they deemed her and her brother suspicious because they were in a more largely white populated area. There was also a recent story this summer where a former NFL player named Brandon Marshall experienced a neighbor calling the police on him when he was trying to enter his own home. Another police practice contributing to racial inequity in housing is tenant criminal record screening. So in the late 80s and also into the 90s, federal law was changed to give public housing authorities the power to exclude applicants with criminal records and to evict tenants who engaged in undefined criminal activity. So one of the things that civil rights advocates and tenant landlords have found is that that phrase hasn't been well defined, and it's led to a lot of abusive practices that have a disproportionate effect on communities of color, which is not a surprise given the correlation between misperceptions about crime and the race of Black and Brown people. Recently, there was an article that came out in Harper's Magazine that provided a little insight into how the drug war was largely treated as a war against Black people and communities of color. So an advisor to Nixon said in a 1984 interview, "You want to know what this was really all about," meaning the drug war. The Nixon campaign in 1968 and the Nixon White House after that had two enemies, the anti-war left and Black people. You understand what I'm saying? We knew we couldn't make it illegal to be either against the war or to be Black, but by getting the public to associate the hippies with marijuana and Blacks with heroin and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did. So in this interview, you can see the political and racist motives of the drug war. And this has the federal policy on drug law enforcement and the harshness of it has been replicated in many state and local jurisdictions throughout the country. And because of these changes in federal law that have used housing law as a tool of the drug war, it's actually led in excluding many individuals from housing, public housing, as well as private housing, when there are private actors who are looking to the federal government, to state government as a model of what types of housing policies they should subscribe to. And just a more recent example of this focus on criminal activity and using that as a basis to exclude people from their housing are crime-free ordinances, policies, and practices. So recently, NBC Bay Area News exposed a housing program that trains landlords to exclude people from housing on the basis of criminal activity. So in this picture, this is one of the training materials. So the program actually works with police departments. In this instance, they were working with the Vallejo Police Department, and they told in their training materials, they're instructing landlords that criminals are like weeds. They also say that criminals is like someone having a potential for criminal activity is like a dinosaur egg, and that once you hatch it, so once you let someone into your housing who has any type of criminal record, that when the egg hatches and it's a dinosaur, there's nothing you can do about it. And so this portrayal of criminal records and allowing it to have any type of criminal activity to have this degree of influence on whether someone is accepted into housing or allowed to stay there, whether it's public or private housing, is really disruptive for communities of color. We know because of the racial disparities in the drug law enforcement and criminal law enforcement generally, that these types of policies are going to result in the exclusion of a lot of people of color from housing opportunities. And that's going to be very critical now, especially in this pandemic. And then finally, another crime-free practice is the automated tenant screening, where private companies have essentially automated their tenant screening process and will rely on other sources that they contract with to provide them with data about what is the history, what is the record of this potential resident. And that has often resulted in incomplete records, inaccurate records being attributed to potential residents, and people have been excluded from housing on that basis. And that also tends to have a disproportionate impact on communities of color. So that is a very wide overview of some of the police practices that are now influencing housing and people's access to it. And I now would like to open it up for questions. I'm happy to discuss more of this with you further.
Thank you, Novella. That was an amazing overview and eye-opening and timely discussion of these issues. Thank you for sharing your time and expertise with us today. We're going to go, I'm Ann Wolf from the Contra Costa Bar Association. I'm the Education Events Director. So again, thank you, Novella, for sharing this with us. I want to let everyone know that we're going to go to a very brief live Q&A when this is over. If you look on the screen that you're watching this on and you look below, you'll see that there's a live Q&A button. And as soon as I finish with the announcements, you can go there and you can ask, work with Novella and ask questions for 15 or 20 minutes or so. So that'll be great. As a reminder, the materials and the evaluation forms for this program can be downloaded from this session page from the Files tab, which is above the chat. Please fill out the evaluation form and email it directly to me. Your attendance certificates will be available soon. If you are a CCCBA member, the attendance certificates will be on the website in your member profile under My Events. If you are a non-member or would like more information on how to get your attendance certificate, please see the information included in our events FAQ tab. If you are having technical difficulties for any reason, there are some troubleshooting tips in the FAQs as well, and we can hopefully help you with that. Coming up next after the break from 1:30 to 3:30, the sponsor meeting rooms and the section networking rooms will be open for you. At 2:30 this afternoon, join us for our live law firm marketing forum with Cara Pryor of James Marketing and Terry Leone and Erica McKenna. At 4 p.m., we have 2 more MCLE programs for you to choose from. One is on embracing invisible disabilities, and one is about the Small Business Reorganization Act. 2 very timely and interesting programs to choose from this afternoon. So after that, and after you've had a chance to visit the sponsors, I'd like you to grab your favorite after work beverage and join us for the entertainment portion of our program. We are supporting our local and award-winning Cal Shakes for a bit of the Bard. Cal Shakes resident dramaturg Philippa Kelly, in collaboration with the Director of Artistic Learning, Clive Worsley, have brought together some of their audience's favorite actors to present some of the most famous Shakespeare trial scenes for your enjoyment. That'll be interesting. See how much or how little has changed in the last 400 years. We will also have our longtime San Francisco comic and comedy club performer, attorney Arthur Goss. There will also be some fun and some magic. So I'd like you to look for your favorite CCEBA friends to make guest appearances as well, or maybe disappearances. So we look forward to seeing you then. So now I'd like to invite all of you to click on the live Q&A button below and join Novella for some live Q&A. I hope to see you there. Again, thank you, Novella, for joining us.